Justice Gavai has had an illustrious career where he acted as standing counsel for various statutory authorities and also acted as additional public prosecutor in the Nagpur bench of Bombay High Court. He was later elevated as judge to the Bombay High Court in 2003. In 2019, Justice Gavai was elevated to the Supreme Court of India, and over the past 6 years, he has decided hundreds of matters involving key constitutional issues and commercial disputes. I would now request Mr. Sunit Malik, Director of EBC Group, to present a token of our appreciation.
It's my honor to introduce Honorable Justice Vikram Nath, Distinguished Judge, Supreme Court of India. After extensive courtroom experience, he was elevated as a judge of the Allahabad High Court in 2004, and he also served as Chief Justice of the Gujarat High Court in 2019, where he made history by being the first Chief Justice to live stream court proceedings on YouTube. In 2021, Justice Nath was elevated to Supreme Court. He has played a crucial role in delineating the boundaries of arbitration agreements and ensuring that contractual terms are upheld, thereby strengthening the arbitration framework in India through several landmark judgments. We welcome you, sir. I would now request Ms. Manuela Vita from CILS to present a token of her gratitude to Justice Nath.
So now it's my honor to introduce our next panelist, Tushar Mehta, Solicitor General of India. Since 2018, Mr. Mehta has been serving as the Solicitor General of India, which is the second highest law officer of the country. He has previously served as the Advocate General of Gujarat and the Additional Solicitor General of India. In his practice over the years, Mr. Mehta has earned a stellar reputation in matters involving constitutional law, criminal law, and corporate litigation, one of the highest ranking law officers of the land. On the global stage, Mr. Mehta has represented India as the lead delegate to the United Nations Human Rights Council during the 41st session in Geneva, exemplifying his diplomatic acumen and legal expertise. And ladies and gentlemen, please join me now in welcoming Mr. Tushar Mehta, beacon of legal excellence and a true guardian of justice, to address us today. I would now like to ask Himanshu to present a token of our gratitude to Mr. Mehta.
I'm delighted to introduce Mr. Stephen P. Finizio, partner WilmerHale, London. Mr. Finizio specializes in international arbitration and dispute resolution. He is widely known for his contributions in the field of energy and finance, and he also serves as an arbitrator. Mr. Finizio holds several positions, few of them being Deputy Director of SOAS, School of Law Arbitration and Dispute Resolution Center, and is also the founding member of the International Dispute Resolution Academy. Mr. Finizio is an eminent member of the GIAC Arbitration Council and is also an advisory committee of the Institute for Transactional Arbitration. We welcome you. I would request Diksha to present a souvenir of appreciation to Mr. Finizio.
So next I'd like to introduce Genevieve, a partner at Lalive. Genevieve is a partner at the Lalive London office specializing in international arbitration and litigation. She has extensive experience in high-value cross-border disputes in the telecommunications, energy, and finance sectors, among others. Legal 500 and Chambers have recognized her as an outstanding litigator and international arbitration practitioner. Genevieve serves as an arbitrator and is a solicitor advocate with rights of audience in the English High Court. She has noteworthy expertise in India-seated and India-related arbitrations, as well as in CIS-related arbitrations. I would now request Diksha to present a token of our appreciation to Kartika. Please present it.
It is my privilege to introduce Mr. Siddharth Dharmadhikari, Additional Advocate General for the State of Uttar Pradesh and Chief Standing Counsel for the State of Maharashtra. He hails from the prestigious chamber of Mr. Mukul Roy, former Attorney General of India. Mr. Dharmadhikari has been an instrumental in high-stake litigation in several landmark judgments. We are confident that his experience and insight will enrich the panel discussions with practical perspectives on how to address the fraud concerns in the arbitration proceedings. We welcome you. I would request Ms. Manuela Vidam to present a token of appreciation to Mr. Dharmadhikari.
I'd like to introduce Abhikalp Pratap Singh, partner at APSAK Consultants. He is a standing counsel for the state of Meghalaya and an advocate record before the Supreme Court of India. Mr. Singh started his journey practicing in the Delhi High Court and the Supreme Court of India with the office of Additional Advocate General of Uttar Pradesh. In 2021, he was appointed to the Global Board of the Foreign Direct Investment International Arbitration Route. Mr. Singh has been appointed Government Counsel for the states of Maharashtra and Madhya Pradesh and Standing Counsel for the state of Meghalaya in the Supreme Court. Mr. Singh has also been appointed arbitrator by the Delhi High Court and conducts arbitrations under the aegis of the Delhi International Arbitration Center. And with that, the introductions, which have done no one justice, are ended. And I turn it over to Abhikalp.
Nope.
I would now request Christina to present a token of our gratitude to Mr. Singh.
Thank you, Chris. Good evening, everyone. I welcome you all today for this discussion. I extend my warm welcome to our esteemed panelists for the evening who have made immense contribution to the world of arbitration. The question posed today's evening is quite peculiar. What can and should arbitrators do when fraud or corruption is suspected but not pleaded? And how can and should the courts help or restrain arbitrators? Without much ado, I request Honorable Chief Justice of India to share his thoughts.
The distinguished panelists and the distinguished audience, a very good evening to all. The increasing prominence of arbitration as a preferred mechanism for resolving commercial disputes has prompted a heightened focus on the integrity of the arbitral process, particularly in cases involving suspicion of fraud or corruption. This concern becomes especially acute when public funds are at stake, such as when the party to the dispute is a state. While arbitration is designed to be efficient and party-driven, it must not become a vehicle to shield illicit conduct from scrutiny. However, this rise in prominence also brings with it certain challenges. One of the most pressing being suspicion, but not the formal pleading, of fraud or corruption within the arbitral-driven domain. This complex legal and ethical terrain has prompted a series of judicial decisions, institutional guidelines, and theoretical framework addressing the duties of arbitrators and the supervisory role of courts. Historically, Indian courts were cautious about allowing arbitrators to adjudicate matters involving fraud. The early decision in Abdul Qadir Shamsuddin Gubray versus Madhav Pravakar Oak set the precedent that courts would refuse reference to arbitration where fraud was alleged, particularly if a party sought an open trial, but a condition of sufficient cause was required to be shown under Section 20, subsection 4 of the Arbitration Act 1940 to resist the reference depending on the facts of each case. This approach was discussed in Yan Radhakrishnan versus Maestro Engineers, where the Supreme Court held that complex fraud claims required a detailed examination and those were more suitable for civil courts rather than the arbitration proceedings. This ruling, however, was criticized for undermining arbitration agreements and thereby leading to increasing judicial interference. Subsequent jurisprudence marked a gradual shift towards arbitration starts. In World Sport Group versus MSM Satellite, the Supreme Court emphasized the special separability of arbitration clause from the main contract, reinforcing the idea that fraud in the main agreement does not necessarily render the arbitration clause inoperative. The court clarified that allegations of fraud, unless they violate the arbitration clause itself, are not sufficient to deny arbitration. In 2014, the 246th report of Law Commission of India on amendment to the Arbitration and Conciliation Act 1996 suggested to introduce a blanket provision after subsection 6 to section 16 of the Arbitration Act, bestowing upon the tribunal the power to make an award despite allegations of fraud. However, this proposal was never adopted by the Parliament, leaving courts to apply judicial standards on a case-to-case basis. A decisive violation occurred in Swiss Timing versus Organizing Committee, where the Supreme Court declared the Radhakrishnan judgment for incurring or ignoring section 8 and 16 of the Arbitration and Conciliation Act 1996, which grants arbitrators the authority to rule on their own jurisdiction. Here the court also highlighted that criminal proceedings do not bar arbitration and that the allegations of fraud should not derail the arbitration process prematurely. In AIS Hon'ble versus A. Paramasivam, the court introduced a distinction between fraud simpliciter, which could be arbitrated, and the serious fraud requiring judicial scrutiny. This was further developed in Rashid Raza versus Sadaf Khan, which established a twin test whether the fraud permits the entire contract and arbitration clause and whether it affects the public domain. The principle culminated in Airtel Post Studios Limited versus HSBC PI Holdings, where the court ruled that allegations of fraud can only render dispute non-arbitrable when they involve the state or touch upon matters of public policy, such as arbitrary or malafide conduct by public officials. These cases revolve around the jurisdictional question of whether courts or arbitrators should handle fraud allegations. However, they offer limited clarity when it comes to dealing with suspicion of fraud. In this regard, the 2024 International Chamber of Commerce report on red flags and other indicators of corruption in international arbitration provide a structural methodology for arbitrators to identify, validate, and assess corruption risks. According to it, there can be two categories of red flags. General red flags relate to the immutable contextual characteristics of the country, geography, or government administration in question, as well as business sector. Specific red flags relate to facts or circumstances pertaining to the counterparty to the proposed transaction. The relationship or payment where a third party is involved or the transaction itself. However, they must be validated through evidentiary analysis and linked to legal standards of corruption. The ICC three-step methodology includes identifying red flags, validating their factual basis, and assessing their legal relevance. Arbitrators are cautioned against overstepping their mandate by investigating vague or immaterial red flags that could violate due process or lead to unenforceable awards. Furthermore, arbitrators face the challenge of ensuring enforceability awards while maintaining neutrality and procedural fairness. According to the ICC framework, they must balance 5 key duties. First, arbitrators must adjudicate the issues submitted by the party without veering into unnecessary investigation unless strongly warranted. Second, arbitrators are obligated to consider legal rules containing corruption. Third, awards tainted by corruption risk, non-recognition, and thus ignoring red flags would jeopardize the validity of the award. Fourth, even when corruption is uncovered, arbitrators must not become biased. They must ensure due process and provide both parties an opportunity to respond. Lastly, the arbitrators should not address issues not submitted by the party unless they provide a fair opportunity for parties to be heard on newly raised concerns. In cases involving suspected fraud, arbitrators must uphold a set of minimum standards to preserve the legitimacy and enforceability of the arbitral process, including the duty to identify and validate red flags. Practically, when fraud is suspected, arbitrators should take reasonable procedural steps. These steps must be taken carefully to balance efficiency with due process and to avoid prejudicing either party without evidentiary justification. Moreover, because of insufficiency of evidence or because of other considerations like political repercussions or a party bearing the defense against a claim of non-performance of a contract, citing red flags relevant to corruption but without making an explicit case. When a party raises a tacit case of alleged corruption through red flags, it may be in the hope that it will be picked up by an arbitral tribunal, thereby leading to a finding of corrupt practice. In such a scenario, arbitrators may take measures such as ordering further fact-finding or expert analysis, suspending proceedings during parallel investigation, and reporting confirmed corruption findings to relevant state authorities, with disclosure of information sometimes required by public policy, including anti-money laundering regulations, despite the confidentiality of arbitration. While arbitrators are increasingly expected to address red flags, national courts retain a critical role in reviewing arbitral outcomes, as demonstrated in Nigeria versus Process and Industrial Development. Courts may set aside awards where corruption is discovered, especially if the tribunal ignored credible evidence or misconduct during the proceedings. Courts are also empowered to grant or enforce interim measures such as asset freezing and evidence preservation. Furthermore, as arbitral tribunals cannot compel third parties, they may depend on national courts to compel witness testimony or order depositions, particularly when witnesses are outside the tribunal jurisdiction. Today, arbitrators are no longer passive adjudicators, but are increasingly expected to proactively address suspicious of illicit activity, even when not formally pleaded. Courts in terms of both as guardians of arbitral integrity and as safety nets. The challenge is most pressing when the state is involved and public funds are at stake. In such scenarios, both arbitrators and courts must act not merely as neutral adjudicators, but as custodians of public interest. I am thankful to the organizers for giving me an opportunity to be here, and thankful to all of you for giving me your ears. Thank you.
This was an enriching and intellectually stimulating discussion. Certainly made each one of us delve into the core principles of arbitration as a practice and called for a strong look into the ethical standards in place. Now I would request Honorable Justice Vikram Nath, Judge Supreme Court of India, to enlighten us.
Thank you for having me here. It is my pleasure to share the stage with such distinguished guests and panelists. Firstly, I would like to appreciate the organizing committee for selecting such a relevant topic for today's discussion. The issue certainly calls for a thoughtful and enriching deliberation. Courts of law very well have the power to set aside an arbitral award on grounds of it being against public policy, especially in cases of alleged fraud. There are similar provisions in the two jurisdictions, Section 68, challenge as they call it in the UK, under the English Arbitration Act, and we deal with such concerns under Section 34 of the Indian Arbitration Act 1996. However, today's discussion is not as much about the challenge before the court or court's interference. Rather, it is precisely about the arbitrator's role where fraud, corruption is suspected but not pleaded. I believe that irrespective of the difference in adjudicator, difference in forum, or difference in the dispute resolution, method adopted, fairness has to be considered the end all and be all. The holy grail of arbitration, or else this resolution system, will always remain an alternative method and not a prioritized one. The scope of today's discussion emanates from the celebrated judgment of the High Court of Justice in the case of Nigeria versus Process and Industrial Development, wherein the judge found without reluctance that the awards were obtained only by practicing the most severe abuses of the arbitral process. We can all agree that most severe abuses is a bulky phrase which clearly points out that the abuse, fraud, corruption was too apparent as to not factor it in. When such is the intensity of malpractices involved in the process, I fail to understand how is the alternative of not identifying and removing fraudulent means even a real alternative or at least an acceptable one. For that matter, the High Court had also highlighted that the corruption involved in procuring the contract alone was not sufficient to warrant the award to be set aside. Rather, it was the process in which the awards were obtained by fraud during the arbitration. It is correct that an award being obtained through fraud is different from the fraud being committed during the commercial transactions, as the former essentially means that fraud is being committed in a process that is aimed at resolving a dispute, and such a practice should be considered inherently unfair, as it directly attacks at and defeats the end goal of justice. Further, we cannot lose sight of the fact that such fraud corruption will have even larger implications in international arbitration, especially where state is a party, and there is a direct bearing on public funds, as it can lead to a high cost impact on a developing country, like in Nigeria's case. Such an award, which ignores the crooked methods adopted, will clearly have its roots in injustice, as the developed and more powerful countries will always have advanced resources to make their headway into a path that is laden with corrupt practices. The inequality in distribution of resources should not further perpetuate unfairness by letting the powerful leverage their advantage and employ fraudulent means to manipulate arbitration clauses in a manner that defeats public policy. Consider the travesty of justice that would have been caused where the arbitral award imposed a liability of $11 billion, and to put things in perspective, this amounted to nearly half of Nigeria's annual budget for 2023. To think that such an award was attained by using deceitful means and would have been enforced if not for the court's decision. This sense of potential injury in itself issues a clarion call for the action and shift in a proactive approach by the arbitrators to ensure a cleaner process. When considering this judgment, the question also arises that the statement of the court that the tribunal did what it did with what it had. Is this really a reasonable justification? Can the tribunal really close its eyes to the acts which practically amount to murdering the sense of justice in the dispute resolution process? I emphatically believe no. While saying this, I am fully cognizant of the conventional and limited role that an arbitrator has to play in the process. However, the question that I ask myself is that can an arbitrator's duty be considered to lack an initiative at fairness? Certainly not. I say this because it cannot be fathomed that the bedrock of arbitration as a process is completely devoid of principles of fairness and justice. If that were the case, then this merely reduces arbitration to a game of which party can achieve their goal either by hook or crook, wherein the end justifies the means. As a judge, I am unable to concur to this opinion. I believe the endeavor of truth-seeking in disputed matters cannot be completely abandoned in the name of arbitration being a party-led process. In fact, if arbitration is to gain further legitimacy in the eyes of parties, the principles of justice need to be at the core of the pursuit. At the same time, yes, a balance has to be struck, a line has to be drawn. An arbitrator certainly cannot be expected to look and investigate into the concerns of fraud by themselves. They can merely flag a concern and then return the appropriate finding based on what each party brings forth in their evidence and arguments. Nevertheless, I trust that nudge from the arbitrator in the right direction will go a long way in cases where the parties are also diligent about protecting their respective interests. The next question that arises is what are the factors that can be considered in order to rid the arbitration procedure of fraudulent concerns. At the most rudimentary level, an arbitrator should see whether principles of natural justice are followed or not. A full and reasonable opportunity of hearing must be given to each party. An arbitrator is expected to be completely neutral, especially in cases of international arbitration, wherein factors like inherent bias or arbitrators' familiarity of laws of one jurisdiction over the other might lead to an imbalanced decision. It again becomes an arbitrator's duty to consider the imbalance in power and resources as an important factor. An arbitrator can probably not balance the scales wherein such disparity prevails, but the least that can and should be done is to provide a fair playground which has no space for convoluted practices. The more I thought about the legal conundrum at hand, the more firmly I started believing that perceived injustice ought to be the metric that an arbitrator implements in such scenarios, as was done in the Nigeria versus PNID case. I am fully aware that the term perceived injustice can be ambiguous and widely encompassing. At the same time, the parameters that will govern this principle is a matter which would involve contentious deliberations and in-depth considerations of various factors and especially the jurisdictional variation. Before proceeding to my concluding remarks, I intend to suggest certain safety mechanisms that can be introduced in order to adopt a fairer arbitration process. Firstly, a stronger, clearer and more judicious drafting of arbitration contracts is need of the day. The practice of using standard contracts without curating them as per the specific needs of that particular project needs to be deprecated. Then again, it is most essential that proper and ethical professional standards are practiced as well as enforced during the process of arbitration. If any faulty practice is detected, action must be taken so as to have a different deterrent effect. Different ethical standards prevail across different jurisdictions, which would make the job even harder at a global forum. But the core values need to be laid down and reiterated in order to introduce a uniform standard of practice. The parties involved should not exploit the confidential nature of arbitration to mean as an avenue to employ dishonest tactics. As for the courts, they should encourage the arbitrators to adopt a proactive approach while dealing with such matters as justice needs to be served, despite the mechanism of dispute resolution adopted. A fine balance has to be struck between becoming a pro-arbitration jurisdiction and at the same time to not shrink away from intervening in the arbitration process. If it goes against the public policy and raises concerns of practices, the award will lose its value and the process will lose its credibility if clear and stern steps are not taken against such practices. Undisputedly, arbitrators cannot act as counsel for a particular side, even if they suspect fraud, but they can definitely call for stricter standard of proof and proper compliances when prima facie some deceitful practice seems to be at play. I certainly second the view that arbitrators can also not act as judges due to the peculiar nature of the process. However, that should not stand in the way to delve deeper and unearth the truth in matters where fairness is at stake. Lastly, I would conclude on the note that when some nefarious conduct is apparent on either party's side, it is not enough for an arbitrator to say that their hands were tied. Corruption is a vice that can hollow any noble endeavor, and it is rightly said that there is no greater disaster than greed. Therefore, honesty and integrity should be made the bedrock of the profession, and then only the arbitration process will bear fruitful results. Nigeria versus PIDL judgment has shone a brighter light on the world of arbitration, which is expected to now adhere to greater standards of integrity, and the discussion this evening is a testament to that sentiment. Thank you very much.
It comes as no surprise that Justice Nath in his address sought the arbitrators and courts alike to act as a guardians of justice, as he very rightfully said that the endeavor of truth seeking cannot be abandoned in the process of arbitration merely because it's a party-led process. I cannot agree more with the proposition that justice has to be done, and factors such as imbalance of resources of power, yielded by either of the parties have to be considered while analyzing the preponderance of defrauding needs. Thank you, sir. Now I would request Mr. Tushar Mehta, sir, the Solicitor General of India, to present his views on the topic.
Honorable Chief Justice of India, Justice Gavai sir, Honorable Judge, Supreme Court of India, Justice Vikram Nath sir, and my colleagues on the dais and off the dais. I first of all congratulate the organizers to not only organize this function but to select a topic which is the topic which is most relevant in the present circumstances. So far, we have been turning a blind eye, either negligently or otherwise, to this burning issue. But for the first time, I believe the High Court in Nigeria versus PAD case has opened up several vistas. But there are several questions which need to be answered before we analyze this. See, fraud and corruption is the ultimate thing which can vitiate every procedure. But when we talk about fraud and corruption in the realm of arbitral proceedings, we are necessarily and by and large talking about arbitral proceedings arising out of a public entity like government of Nigeria, or a public sector undertaking and a private party, and the private party is the beneficiary of the fraud committed by the officials of the government or the private sector undertaking, as was the case in Nigeria. What would happen in case where both sides before the arbitrator are private parties? It is not unthinkable that private parties also can collude with each other, enter into a transaction and get the transaction legitimized by appointing an arbitrator and getting an arbitral award, which is a quasi-judicial award, which is enforceable in the court of law. What would happen if the arbitrator were to notice such a collusion, which may be result of either fraud or corruption at both ends or at one end? There has to be an answer. The answer is definitely that he has to intervene. He owes a duty to himself, first of all, to intervene, and owes the duty to the parties to intervene. But the problem will be, to what extent will he do that, especially when we are looking at a scenario where there are no pleadings, because either you take fraud or corruption, you need pleadings. Of course, that may not necessarily mean that arbitrator cannot go beyond the brief is given, because the arbitrator has a right under the statute, each domestic law which governs the arbitral proceedings, or whichever is the curial law governing the arbitral proceedings, to call for information, call for record, call for documents, call for affidavits, and he can even examine and cross-examine witnesses on his own. Now, there are 4 stages where this question may arise. The first stage is where fraud or corruption has taken place at the stage of entering into the contract. One party was definitely fraudulently inducing the other party, who is managed by private individuals, like in case of Nigeria. Second category of fraud or corruption can arise during the implementation of the contract. The contract per se is a valid contract without being tainted by any fraud or corruption, but during the execution of the contract, there was a collusion, there was a corruption, and a fraud played by one party. As a result, the contract could not be completed. Third and most important, and let us not turn our eyes from that, the fraud committed during the arbitral proceedings itself, when the arbitral award is the result of the fraud. Now, when we are entering into an arena which is not statutorily recognized or statutorily regulated, one more question would arise. Take, for example, a contract between a public sector undertaking and a private company. Public sector undertaking obviously acts through individuals, and individuals are amenable to pressure, amenable to fraud, amenable to corruption, amenable to collusion, etc., etc. There is a contract entered into which is tainted by fraud or corruption. Let us take an example that even the execution of the contract is also tainted by fraud and corruption. As a result of which, the party suffering the fraud and corruption would say that we would feel more safe in going and getting our dispute adjudicated before a competent court of law rather than going before a party chosen arbitral tribunal. And a private party approaches the competent forum. In India, it is the High Court or the Supreme Court in case of international arbitration, and it may be different in case of other domestic laws. Can the party opposing arbitration raise the ground of fraud to oppose appointment of an arbitral tribunal? These are the questions which will have to be answered either by the evolving jurisprudence by honorable courts or by making a statutory provision. Friends, I can share that our government, Indian government, came across a very huge case of fraud where the contract was entered into fraudulently, the execution was fraudulent, and the award was passed. I will not take all the stages. Ultimately, the government of India had to take a decision to present a bill before the Indian Parliament amending section 34, which is the provision for challenge to an arbitral award, and now fraud is a valid ground for challenging the arbitral award. I believe that's what the position in England also is. Fraud is a ground. But suppose in a case where parties are governed by law of either law which is neither an Indian law nor English law, some other law, this is not a ground of challenge. Therefore, in cases of arbitral contracts or contracts containing an arbitration clause, what is most important, according to me, is two things. One, the drafting of the contract itself, which is in many a times found to be lacking when we deal with the arbitration proceedings. And second, absolute impartiality and integrity of the arbitral tribunal. Unless and until the second part is secure, the question all of us will have to ask ourselves is, can we trust a forum created by us with power to adjudicate something which is not even pleaded? It's a question very difficult to answer, but will have to be answered because we have already entered into an arena where fraud and corruption is a part of either contract making, execution, arbitral proceedings, or further proceedings. Whatever my Lord the Chief Justice and my Lord Justice Vikram Nath has said is, as per our constitution, binding on me, and therefore I concur with whatever his lordships have said.
We decide what you argue.
So I just presented a lawyer's perspective while fully, respectfully endorsing what his lordships have said. I really thank both Mr. Dharmadhikari and Mr. Singh that I was given an opportunity to sit on the same dais as the luminaries who are present here. And I thank all of you for giving me a very patient hearing. Thank you so much.
Thank you, sir. Lieutenant SG sir was quick to point out the delicate balance that has to be struck in an arbitrator's duty in such matters. His address brought forth a very pertinent concern of how the fraudulent schemes in themselves have become increasingly sophisticated, thereby complicating the job of trust protection. Thank you, sir. Now I would request Stephen and Genevieve to further this discussion.
Thank you so much for that introduction. Thank you to the members of the panel. I'm very humbled to be on this panel. I'm not quite sure how I got here. And So I'm going to be sharing the floor for the next few minutes with Steve, who will certainly help me out. But I did want to say thank you for the topic yet again. It is a topic that sits at the intersection between law and ethics and public trust, and so entirely pertinent. And the question, what should arbitrators do when faced with indicia of fraud or indicia of corruption? It has never really been an academic question, but now, and when we see PNID and other similar cases that I think Steve will talk about, it's a practical reality that we have to confront with profoundly consequential effects. We've heard the buzzwords already on the panel: red flags, public policy, compelling witnesses, and so Steve and I are going to touch on those elements in the following order. So first, talking about the arbitrator's mandate. What is the mandate of an arbitrator? What are its limits? And then, does the arbitrator have a duty to act? And I'd like to touch on perhaps something that hasn't been spoken about yet, how the institutions or guidance are getting their hands around suggesting to arbitrators what to look out for, perhaps how to reconcile the competing duties and obligations, and putting their hands around just how they can enforce or deal with the problems that arise. And then we'll come on to talk about PNID, PNID, and similar cases, perhaps what the tribunal could have done differently if we have the time, and otherwise the safeguards that can be put in place. So starting with, the arbitrator's mandate and its limits. The mandate is, as we've heard, they are there to resolve the dispute that is presented to them, the party's case that has been put before them. They can apply mandatory rules. They must ensure that their award is enforceable, and that includes not being tainted by illegality. And then, as we've just heard, they also have to remain impartial and avoid bias. And in terms of resolving the dispute that is submitted to them by the parties, we will come on perhaps to talk about a sort of sua sponte investigation. But deciding what course to take is obviously easier when a party has put forward an issue of fraud or corruption, whether that is legitimately made or whether it can be cast aside because it is not an allegation that's made in good faith. But it is much more difficult for an arbitrator to determine when or not they should investigate and how if they see a risk arising. And there is a chilling effect that by inquiring into corruption on your own bat, the tribunal might risk contravening issues of public policy. So the party's right to equal treatment, as we've heard, the party's right to be heard, basing a decision on a fact that wasn't raised by one of the parties may violate, or could be said to violate, a party's right to present its own case. And there are limitations, as we've just heard. The arbitrators don't necessarily have the tools that a court does. They're not criminal judges, they're not investigating magistrates, so necessarily their task, their role is inquisitorial. It's not, pardon me, it's more adjudicative than inquisitorial, and lacking those investigative powers that would aid in gathering evidence. And we can talk about where they can look to for those powers, but certainly they won't have police powers. They won't be able to impose criminal sanctions. Is there a duty, nevertheless, to report and to raise the red flag that has been put before them in a private forum? And are they bound, in fact, by the party's submissions? Under certain arbitration laws, the domestic courts at the seat of the arbitration are available to assist a tribunal in compelling both the production of evidence and delivering up witnesses, although that's more in securing the attendance rather than forcing an attendance. And again, there's a difficulty perhaps when you've got domestic courts that are at the seat of the arbitration as opposed to domestic courts abroad, and whether or not the tribunal has a power to compel in those circumstances. And in terms of other tools that are available to the tribunal, I'm going to pass to Steve, perhaps.
Thank you, and let me also give my thanks for being here and with this unbelievably eminent panel of speakers. It's a great privilege. We're going to bounce some ideas from the international arbitration perspective off of each other in reaction to the judicial and the governmental perspective on this. So that's what our goal is. Before I jump into other tools arbitrators can use, because we've talked so much about P&ID, and we may come on later on to give you some details, because I'm sure not everyone in the room will know all of the details of P&ID. I do think it's important. The judge in that case, when he decided it, because we're dancing around this, he said, and I think this is really important, he said that the arbitration community needs to consider whether the arbitration process, which is of outstanding importance and value in the world, needs further attention where the value involved is so large and where state is involved. So he threw down a challenge, which is what I think we're doing today. We're dealing with that challenge that Justice Knowles set down. And we'll come back to the details, but I think that sets the context for everything we're talking about. Now we're talking specifically about limits on arbitrators, but also tools arbitrators have. And we've talked already about balancing fairness to the parties with also the limited abilities arbitrators may have compared to courts to compel evidence or to otherwise investigate a case. And we'll talk a little bit about this vitally important issue about whether an issue of corruption or fraud is raised by a party or the tribunal suspects that there's an issue. But I do want to put a counterbalance in here. There are things arbitrators can do, which we don't always talk about. There are things arbitrators can do to investigate if they choose to do so, or allow parties to investigate if a party has actually made an allegation of fraud or corruption that judges can't always do. And I mean that particularly in the context of an international arbitration. Because in international arbitration, and we had a list of the different ways corruption and fraud come up, there may be corruption in the creation of the contract, there may be corruption in the execution of the contract. So let's assume a large number of corruption cases in arbitration involve a party seeking to enforce payments due under a contract that either the arbitrator suspect or the other side says was a contract for either corrupt behavior or was obtained corruptly. And where it gets interesting in arbitration is a judge sitting in India can compel evidence within India and can compel evidence and bring witnesses in. But what the judge can't do is necessarily get evidence from abroad. Arbitrators don't have an ability to compel evidence, but what they can do is if a claimant is seeking a payment on a contract that the arbitrators or the respondent claims is corrupt, arbitrators can require the claimant to provide evidence. And if the claimant fails to provide evidence, they may then lose the case. So there's an ability to get an international form of disclosure of evidence that isn't available to domestic courts or to investigators in various states. And I'm taking this on a digression, but I thought we're talking so much about the limits on what arbitrators can do. I have been involved in cases, and let me be really specific about this. I've been involved in cases where an agent, under a consulting agreement, has sued a company for hundreds of millions of dollars for failure to pay, and the company has refused to pay on the basis that they suspect that the contract is for paying a bribery to government officials. And the arbitrators have ordered that the claimant provide, for example, bank records of what they've done with the payments they've received so far. Now that claimant is in a dilemma, because if they refuse to provide that evidence, their case is over, because that is evidence within their control. A court in India, for example, couldn't demand that someone brings their court records from Portugal. But an arbitrator has that power to the extent that the party wants to actually pursue the claims. So there is an ability to gain evidence sometimes that we overlook with arbitration, and that's a bit of a digression. But I wanted to make sure we talk about that. But we do have much more significant limitations, and one of our main tools that we often talk about in international arbitration is the use of inferences. And now, the use of inferences is complicated. As anyone who's ever tried to get a tribunal to draw adverse inferences, we are very strict in arbitration procedures about what we will allow inferences to be drawn with regard to. They're often very limited. And when we start talking about questions of corruption or fraud, arbitrators are very reluctant draw inferences, but this is the main tool. But we're building requests for arbitrators to draw inferences off of circumstantial evidence. We've had a lot of discussion of red flags. Now, red flags are never direct evidence, right? Red flags are circumstances which should lead you to think that maybe something suspicious has happened. And so the question becomes, how strong is a tool to draw adverse inferences when the basis for the inference is this contract was made in certain circumstances, maybe within a certain country, within a certain industry, between certain people, where we think it's more likely criminal activity may have taken place. But is that enough to give an effective tool for drawing adverse inferences? So I do think one of the big limitations we have is the tools we use in arbitration to make conclusions about possibilities of fraud and corruption are not only limited by the lack of ability to compel evidence, but they're limited by the fact that things like adverse inferences are hard enough if it's a mere failure to disclose documents, let's say. But when it becomes, should we draw an inference based on circumstances like red flags, I think arbitrators are very reluctant to go there, which is one of the problems we see in this balancing of this idea of equal treatment and fairness versus the importance of rooting out corruption. The tools we give to arbitrators often leave them in a very vulnerable position in terms of how far they can go. And I'm digressing wildly, but I think that leads also to what we see often in arbitrations, which is arbitrators will decide against a party where there are suspicions of corruption, but not say that's why they decided against the party, which leads to another thing that I think is an issue, which is, and judges do this too, but I think arbitrators are more guilty of making a decision on one basis, being influenced by another basis. And I think that's something where these sorts of conversations lead us to maybe have more clarity about saying if the decision is based on a conclusion that there was corruption or fraud, let's say that out loud, rather than deciding that a breach contract wasn't proven or some other basis hasn't been proven. But I think this is one of the inherent problems we have in arbitration, which is arbitrators are nervous about accusing parties of fraud or corruption. Even there's partly a selfish reason for that. They depend on being reappointed. But there's also a nervousness that they don't have the same powers that judges have, and therefore they're reluctant to take such drastic decisions. So I've taken us on wild digressions. I've deviated from our points dramatically, but I wanted to make those points. And I'm going to give it back to Genevieve to get us back on track.
I don't know that I will get us back on track, but no, I think it's a relevant tangent, if you like. And the whole conversation really is about empowering arbitrators to say what they mean and perform in a way that upholds their sort of moral convictions. And I think exactly so, figuring out what the tools are that are at their disposal, being honest about using them, and where there is fraud or corruption, having the courage to properly call it out instead of, as Steve says, treating it as sort of a factor that sits behind the decision that is decided on. The contract leans one way or the other. And I think encouraging arbitrators to recognize that they do have these investigatory tools available to them, that they are permitted to investigate both the law and the facts, even if they are not put before them. So the sua sponte element is not so wild or dangerous. The court knows the law, and so the tribunal should feel empowered to inquire if there is a legal impediment, which can include allegations of corruption or bribery. And similarly, as Steve was saying, as to the facts, a tribunal is almost, in many jurisdictions and under many of the rules, entitled to look into the facts and to satisfy itself. And often, and I think a best practice, is for the courts to inquire of the parties and to let them know that that is what is on their mind, and to allow an opportunity to respond. So not digging around in the undergrowth unannounced. But otherwise, yes, the tribunal does have the ability to investigate. I think we've been given a 5-minute call, a 2-minute call. So let us move then just to, again, how the tools that we can give to the arbitral community, the arbitrators, the tribunals, to investigate bribery and corruption. And some of that would lead us to the ICC's recent publication last year. There was a publication around the red flags And I don't know if you want to take some of that, Steve, or if I...
Well, why don't we, because we have 2 minutes. And the good news is the other speakers have covered the fundamentals so well that we're just adding a little gloss from an arbitration perspective. Let's quickly run through tools. Tools are the ICC guidelines for red flags, which were published in 2024, are hugely useful. The Chartered Institute is starting this summer a series of workshops on how to handle issues of corruption in ADR processes. We are seeing arbitration institutions starting to wrestle with this. When during the amendment, the process of amending or updating the English Arbitration Act, the Ministry of Justice actually asked leading institutions to report on their mechanisms for looking both for sham arbitrations as well as for thinking about how we look for corruption or fraud in the underlying cases. And they are thinking about this. We haven't seen huge progress in revising rules. The LCIA says in their rules that if you see fraud or corruption, you should be aware of that, but it's not a particularly prescriptive or detailed approach. But we are seeing efforts to do this. There was an effort during the revision of the English Arbitration Act. There was a proposal to make an affirmative duty or an obligation for arbitrators to consider fraud and corruption, and the decision was made not to include that duty, in part because the feeling was this is being addressed by institutions and arbitrators are more aware of it, in part because it felt like this might create an unexpected ground for challenges, because the losing parties might then say, well, we threw an allegation of fraud or corruption into the case, you didn't do enough to investigate, and therefore we want the award set aside because the arbitrators failed to investigate. And so I think the decision was made not to include that duty, but that discussion started. So I think there's a lot of I think more attention. And while P&ID, which we didn't get to, and I'm happy to go into the details later, it had every element that the Honorable Mr. Mehta brought up, including not in the decision, but suggestions that the arbitrators were corrupt and that the counsel for Nigeria was corrupt. That didn't form parts of the decision, but at every element that you could come up with corruption, I think has been a real wake-up call. And we're seeing the use of fraud and corruption as a grounds, as a defense in treaty cases now almost nonstop. So we will be forced to wrestle with this and how arbitrators can learn to be better about spotting these issues and using the powers they do have, which are more extensive than they want to believe, including in terms of asking for evidence, putting parties to the test by saying, we have questions, we're telling you, we're not going to be quiet about this. We're going to tell you as a tribunal, we want you to tell us what happened here, because we see red flags and we want to be comfortable that there aren't issues here. So I think we're going to see a huge increase in the amount of attention we pay in the world would be a better place in this process. I think we're done.
Thank you. Thank you, Steve.
Chief Justice is on a tight schedule and I'll keep this short. Justice Bhushan Ram Krishna Gavai, Honorable the Chief Justice of India, Justice Vikram Nath, Judge Supreme Court of India, before whom I have the pleasure of appearing every day. Mr. Tushar Mehta, the Solicitor General of India, with whom I have the pleasure of appearing every day. Mr. Stephen and Ms. Genevieve, Abhikalp. On behalf of everyone, I sincerely extend my gratitude to Honorable Chief Justice, Justice Vikram Nath, and everybody on the panel to be here and enrich everybody with their thoughtful insights. Thank you so much, sir.